The ground beneath every gun owner in America just shifted overnight. A shocking Supreme Court ruling has ripped through decades of so-called certainty, forcing police departments to scramble, rewriting training manuals, and leaving millions of armed citizens dangerously unprepared. If you carry a firearm and you don't know the new rules, the next set of flashing blue lights behind your vehicle could be the moment everything changes. Not tomorrow, not next year, but today. One wrong word, one careless gesture, and you could find yourself in handcuffs, stripped of your rights, or worse. What I'm about to share isn't just legal theory. It's a survival blueprint. These rules aren't taught in your concealed carry class. They're not whispered in gun shops, and most lawyers won't tell you until it's too late. But now, because of this ruling, the entire playbook for police encounters has been rewritten, and only those who adapt will walk away with their freedom intact. Stay with me until the end, because rule number 1 is so explosive, it's sending shockwaves through law enforcement agencies nationwide. And if you value your life, your liberty, and your family's safety, you can't afford to miss it. Here is the rule that will absolutely blow your mind, because it hands you a legal superpower most gun owners don't even know exists. It is simple, it is powerful, and once you invoke it, the entire balance of power shifts in your favor. When a police officer crosses the line and begins to trample on your constitutional rights, there is one phrase that acts like kryptonite. The instant those words leave your lips, everything changes. The phrase is this, officer: I am invoking my Fifth Amendment right to remain silent, my Sixth Amendment right to an attorney, and I do not consent to any searches or seizures. That single sentence detonates like a legal nuclear bomb. From that moment, evidence can be thrown out and statements become inadmissible. If the officer keeps pushing after you invoke, their actions become violations courts cannot ignore. I have seen felony cases collapse, wrongful arrests turn into six-figure settlements, all because a gun owner had the courage and knowledge to deploy this shield. But the real danger is hesitation. If you fail to use it the second your rights are threatened, you hand the officer the upper hand. Memorize this phrase, burn it into your memory. Because in the heat of the moment, this shield may be the only thing standing between you and a destroyed future. This rule is so simple it can be executed in 3 taps on your phone. Yet it has saved countless lives and kept innocent people out of prison. Most gun owners never think to use it until it's too late. The moment you see flashing lights or officers approaching, you must activate what I call the triple documentation protocol. Step 1, begin recording audio or video. Step 2, verbally timestamp the encounter. Step 3, identify any witnesses within earshot. This isn't paranoia, it's protection. Those first moments can be the difference between freedom and financial ruin. Here's the exact script that has shielded gun owners from false charges. It is date and time. I am being contacted by police at location. I am legally licensed to carry and am currently armed. I am recording this interaction for the safety of all parties involved. That one statement does more than capture evidence. It establishes your state of mind. It proves your cooperation. It locks in your constitutional awareness from the very first second. Police know the camera changes everything. And now, under the new legal standard, so do the courts. If you fail to document, you're gambling with your freedom. If you document properly, you create a record so strong it can dismantle false accusations before they ever see a jury. If you live in a constitutional carry state, you might think you can sling a pistol on your hip and walk the streets without fear. That illusion has cost people their freedom and, in some cases, their lives. The harsh truth is, this constitutional carry doesn't make you untouchable. Police can still detain you if they can articulate specific, suspicious activity. What they cannot do is detain you simply for legally carrying a firearm in plain sight. That's where the magic phrase comes in. Officer, I am legally carrying under state constitutional carry laws. I pose no threat to anyone, and I'm happy to cooperate within my constitutional rights. Notice that word, within? You're not refusing. You're setting boundaries and forcing the officer to justify with facts instead of vague feelings. Inevitably, the officer may try to escalate with the familiar line, I need to secure that weapon for officer safety. But under the new standard, that excuse is no longer enough. They must provide specific, articulable reasons why disarming you is justified. Your counter should be calm. Deliberate officer, I understand your safety concerns, but I am exercising my constitutional right to carry. I need you to articulate specific suspicious activity that would justify disarming a law-abiding citizen. That one statement flips the script, pushing the burden back onto them, where it belongs. Your car isn't just transportation, it's your castle on wheels. And when you're armed, the way you handle those first 30 seconds of a traffic stop determines whether you drive home or spiral into a nightmare. Too many gun owners ruin themselves by saying too much, moving too fast, or surrendering rights they don't need to. Here's the protocol. Keep both hands visible on the steering wheel. If it's dark, switch on your interior lights so every movement is clear. When the inevitable question comes, do you have any weapons in the vehicle? Your response must be calm, precise, and legally airtight. Say, officer, I am legally licensed to carry, and I am currently armed. My firearm is secured and poses no threat. I do not consent to any searches of my person or my vehicle. That one sentence does three things. It discloses your status, removes surprise, and sets constitutional boundaries. The game has changed. Courts no longer accept vague claims of officer safety as justification for ransacking your vehicle. They must now demonstrate specific suspicion tied to your behavior. If they can't, their search collapses in court, and your rights remain intact. Your vehicle can be your greatest liability or your strongest shield. The choice depends on whether you follow this fortress protocol every single time those blue lights flare up in your rearview mirror. Your home should be your sanctuary, but ignorance can turn it into a crime scene in seconds. When officers knock at your door, whether for a welfare check, a noise complaint, or under the guise of an investigation, you hold rights most people surrender without realizing. One careless gesture, one misplaced word, and you've opened the floodgates to disaster. Here is the script that has protected countless families, officers. I see you at my door, but I am exercising my Fourth Amendment rights and do not consent to entry without a warrant. I am legally armed, as is my right, and I am happy to speak with you through the door or step outside to talk. The mistake most people make: opening the door wide. Courts have ruled that gesture as implied consent, letting everything inside become potential evidence. Instead, you have two safe options: open the door just enough to speak and step outside, closing it behind you, or don't open at all and communicate through the barrier. Both protect your rights without escalating the situation. Never forget once they cross your threshold without a warrant. The sanctuary is gone. Everything you worked for, everything you own, becomes fair game. Your words at that door decide whether you stay in control or hand over your life to strangers in uniform. Most people believe Miranda rights only matter after they've been cuffed and stuffed into the back of a cruiser. That deadly misconception has ruined more lives than almost any other misunderstanding in criminal law. If you wait until the cold steel is on your wrists, you've already lost ground you may never recover. The truth is simple the moment an officer begins treating you like a suspect instead of a witness. You must invoke. What does that shift look like? The officer's tone shifts to accusatory. Questions become invasive, and your freedom feels restricted. That is the moment to strike. The script is clear, officer. I want to exercise my right to remain silent and my right to have an attorney present before answering any questions. Here's the part most people miss. Silence means silence. Don't explain, don't argue, don't try to sweet-talk your way into innocence. Every additional word is ammunition they can twist against you. Once Miranda is invoked, the rules change. If they press, if they prod, if they keep talking, that pressure becomes a constitutional violation. And when the case hits court, that violation can dismantle everything the state thought it had against you. This rule has saved more lives than any piece of legal jargon you've ever heard. In a world where officers are trained to treat sudden, unexplained movement as threats, the tiniest gesture can ignite tragedy. If you are armed, every motion of your hands, every reach toward your pockets, every shift in your body carries weight. That's why narration is not optional. It is survival. The protocol is exact. Officer, I need to reach for my wallet in my back right pocket to get my license. Is that okay with you? Then wait for acknowledgement. Only then I am now slowly reaching for my wallet with my right hand while keeping my left hand visible. I have my wallet out, and I am now retrieving my license. It may sound excessive, but each phrase builds a record and proves your actions were cautious and announced. Courts must evaluate the full chain of events, including your cues, time and again. I have studied officer-involved shootings where legal gun owners died simply because they reached without explanation. The survivors, the ones who walked away, were the ones who narrated every move like their life depended on it, because it did. Encounters with police rarely explode in an instant. They escalate through patterns, predictable, recognizable, deadly if ignored. If you miss the warning signs, you may find yourself trapped in a situation spiraling beyond control. The signs are unmistakable. The officer's voice sharpens from professional to aggressive. Requests transform into commands. His body language shifts, hand inching toward his weapon. Your lawful activities are suddenly framed as suspicious. Your clear invocations of rights are brushed aside like inconveniences. When those red flags appear, shift into defensive compliance, shorter statements, more verbal documentation, slower movements, and readiness to deploy the silent shield. Here's the script that diffuses tension in 9 out of 10 encounters. Officer, I can see this situation is becoming tense. I want both of us to be safe. I am not resisting, and I am trying to comply with all lawful orders within my constitutional rights. The key words are lawful orders. That phrase carves a legal line between commands they are authorized to give and demands they are not. It tells the officer you know the difference. It creates a record for later court review. And, most importantly, it buys you the seconds you need to survive the escalation and walk away with your freedom intact. The single most dangerous mistake armed citizens make isn't about how they carry, but about what they say or fail to say when questioned by police. Disclosure isn't a simple yes or no. It's a matrix of timing, tone, and circumstance, and making the wrong choice at the wrong moment can get you killed. In duty to inform states, you are legally obligated to disclose that you are carrying, but blurting out, "I have a gun," is the fastest way to make an officer's hand snap toward his weapon. The adrenaline surge that phrase triggers can turn a routine stop into a deadly standoff in seconds. Instead, the safe script is this, officer. I want to inform you that I am legally licensed to carry a concealed weapon, and I am currently armed. My firearm is secured on my right hip, and my hands will remain visible on the steering wheel. Notice what you accomplish here. You establish your legal status. You remove the surprise factor. You specify the weapon's location. And most importantly, you demonstrate that you are not a threat. Disclosure isn't always mandatory. If treated like a suspect, it can still protect you by showing cooperation and avoiding surprises. The key is reading the situation and delivering it with precision, not panic. This is the rule that shatters the old world of police encounters. For decades, officers had a magic phrase, a get-out-of-jail-free card they could pull at any moment to justify virtually anything officer safety. Those 2 words open the door to illegal searches, unlawful detentions, even the use of deadly force. Courts accepted them blindly, and gun owners paid the price in blood and broken lives. But the ground has shifted. A new standard demands that safety concerns be specific, articulable, and objectively reasonable. No longer can an officer wave away your rights by claiming vague fear or general unease about armed citizens. Now, they must prove that your particular words, actions, or body language created a real risk that any reasonable officer would recognize. Here's how you flip the script. When an officer tries to disarm you or push past your rights under the old shield of officer safety, your response must be calm but firm. Officer, I understand safety is important, but I need you to articulate the specific behavior or circumstances that justify restricting my constitutional rights. That phrase forces the confrontation into the light. If they cannot provide concrete reasons, their actions are not just questionable. They are violations. And under the new framework, violations carry teeth-dismissed charges, civil rights lawsuits, even the possibility of criminal liability for the officers themselves. This rule isn't about confrontation, but clarity. For the first time in decades, the balance tilts back toward the citizen, but only if demanded. The difference between silence and assertion could decide whether your family eats with you tonight or visits you through glass tomorrow. Memorize this rule, because when officer safety no longer ends the conversation, your rights finally have a chance. These 10 rules are not suggestions. They are survival tools. Each one is designed to shield you from the traps that turn law-abiding gun owners into criminals overnight. From invoking your rights with the silent shield to dismantling the hollow excuse of officer safety. Every rule is a weapon you carry in your mind as surely as the firearm you carry on your hip. The legal landscape has changed, and ignorance is no longer an option. If you walk into a police encounter without this knowledge, you gamble with your freedom, your future, and your life. But armed with these rules, you can turn the tables, protect your rights, and walk away intact. If this information could save even one life or one family, then sharing it is not just smart. It is your duty. Spread it. Teach it. Protect your fellow citizens.